Mediation has become an essential part of civil litigation in Texas, providing an alternative way to resolve disputes without the time, expense, and stress of a courtroom battle. Instead of leaving the outcome in the hands of a judge or jury, mediation allows both sides to come together with the guidance of a neutral third party, the mediator, to negotiate a mutually acceptable resolution. The concept behind mediation is simple. Rather than engaging in drawn-out legal fights, the parties involved work towards a solution that satisfies both sides. Unlike arbitration, where a third party makes a binding decision, mediation is entirely voluntary. The mediator does not decide the case, but instead facilitates discussions, helping the parties explore options for settlement. If successful, mediation can save substantial legal fees, reduce emotional strain, and allow both sides to walk away with an outcome they can live with. Texas law strongly encourages mediation as a way to resolve civil disputes. The Texas Alternative Dispute Resolution Act, passed in the late 1980s, established a framework for mediation in civil cases. This law allows courts to refer cases to mediation before they proceed to trial. In fact, many Texas judges require mediation before allowing a case to be heard in court, particularly in family law, personal injury, and commercial disputes. If one party objects to mediation, they must do so within 10 days of being notified. Otherwise, failing to participate in mediation could result in court-imposed penalties. So what actually happens during mediation? The process typically begins with both parties selecting a mediator who has experience relevant to the case. Before the session, attorneys may submit mediation briefs outlining their positions, key evidence, and potential settlement proposals. This helps the mediator understand the dispute before discussions even begin. Once mediation starts, it usually begins with a joint session where the mediator explains the process and the rules of engagement. In some cases, both parties make opening statements to present their positions. However, in highly contentious cases, this step may be skipped to avoid unnecessary conflict. The bulk of mediation takes place in private caucuses, separate meetings between the mediator and each party. These confidential discussions allow each side to express concerns, clarify legal positions, and explore potential resolutions without fear of weakening their stance. The mediator acts as a bridge, shuttling proposals between the parties and helping to identify common ground. Unlike court proceedings, mediation is not about proving who is right or wrong. Instead, it is about finding a solution that works for everyone involved. If an agreement is reached, the attorneys will draft a mediation settlement agreement, which is legally binding under Texas law. However, for the agreement to be enforced in court, it must meet certain legal requirements, such as being in writing and signed by all parties. If mediation does not result in a settlement, the case proceeds to trial, but the discussions that took place during mediation remain confidential and cannot be used in court. The success of mediation depends on several key factors. First, both parties must be committed to resolving the dispute. Mediation is not just about showing up. It requires a willingness to negotiate in good faith. Second, transparency is critical. When both sides share the necessary information openly, it allows for meaningful discussions and realistic solutions. Third, decision makers must be present. If the people at the table do not have the authority to agree to a settlement, the process becomes a waste of time. Finally, preparation is crucial. Coming to mediation with clear goals, supporting documents, and an understanding of possible compromises leads to more productive discussions and better outcomes. Selecting the right mediator is also vital. A skilled mediator brings more than just neutrality to the table. They guide the conversation, manage emotions, and suggest creative solutions that may not have been considered otherwise. The right mediator can make the difference between a frustrating deadlock and a successful resolution. Civil mediation in Texas offers a structured yet flexible way to resolve disputes. It prioritizes collaboration over confrontation and allows parties to have control over the outcome rather than leaving it in the hands of a judge. With courts increasingly requiring mediation before trial, understanding how the process works and how to prepare can be invaluable. If you are involved in a civil dispute and are facing mediation, preparation is key. Having an experienced attorney by your side can help ensure that your rights are protected and that you achieve the best possible outcome. If you have questions about mediation or need legal representation, the attorneys at Varghese Summersett are here to help. Search for Varghese Summersett on Google, or you can call us today for a confidential consultation at 817-203-2220. Otherwise, you can find us at versestexas.com.